Pass out case from supplementary list. Item 6, second appeal 156 of 2017.
On behalf of some minors, but without from I could not file, so I am permitted to file that.
माइनस की तरफ से वकालतनामा अलग से क्यों फाइल होगा? You are already representing.
No, wakalatnama for the substituted heirs.
What is this, Mr. Mukhopadhyay? I will impose very heavy cost on you. कल आप नहीं आए?
Actually, आज बहस करेंगे हम.
हाँ तो बहस करेंगे. हम नहीं जानते आपका क्या है. जो नोटिस हो गया है, जो नहीं अपीयर हुआ है, नहीं अपीयर हुआ. We don't bother about it.
The judgment which I was saying, which was against me, 2019-20 SCC 633.
2019.
20 SCC 633. Murugan and others versus Kesawa.
Let's come to the question of law once again. Limitation Act. Question of law.
While order dated 24/9/18.
Just a minute.
Whether the learned appellate court had failed to interpret Article
Just a
6.
moment.
May I read it, madam?
Just. Yes, read the question of law.
Whether the learned appellate court had failed to interpret Article 60 and 109 of the Indian Eviction Act, as well as Section 8 of Hindu Minority and Guardianship Act, in the correct perspective, as there was no partition of the ancestral property belonging to the father of the plaintiff, and further the state lead under challenge did not obtain any permission from the court, which is the mandate of Section 8 of the Act of 1956.
So, this Article 109 has got any relevance?
No, it's Article 109 which says that the father
So,
can
it
do
is
it.
not an alienation by father.
Alienation.
So, it has got no applicability.
Applicability of way. But it is the admitted facts by both the parties that the sued property was not partitioned.
As per Article 60, the suit is barred by limitation.
Barred by limitation, and the law itself of the Supreme Court is clear that it's voidable, not void ab initio. 8-2, if it's not voidable.
So, Article 60 would apply, and admittedly, the suit was filed beyond 3 years.
Beyond 3 years. That Supreme Court has had, my lord, that Section 8(2) provision is not followed, then it's voidable.
Yes.
That is followed by the
Date of- So, your suit for setting aside the sale deed is barred by limitation.
barred by limitation.
So, what further do you want to add?
My lord, there are 3 points, my lord. In the plaint itself, my lord, and in the written statement, it is an admitted fact that the suit at that time was not partitioned. So therefore, which is said that the mother had sold the land of the plaintiff when he was a minor, how it was allotted when the partition was not happening between them. So then it will be not governed by Article 60, it will be Article 59 will come in play. which is admitted by the defendant also in the written statement. And that judgment I had relied yesterday, my lord, of Article 59. That it has to be from the date of knowledge. And second, my lord,
Just a minute. How do you say that 59 will come into play and 60 will not come into play?
because the partition did not take place.
So,
So that's why, my lord, the portion was not settled. That portion which was sold to the defendant was the portion of the plaintiff, because after the death of the father, there were three legal heirs: the mother at that time and both the child. And admittedly, the property was not distributed among them, which has been admitted in the plaint and in the written statement. Also, the defendants have said that the partition did not take place. So, Article 16 goes.
your elder brother also sold the property.
Yes,
That was not under challenge.
That I filed a suit against him. That is separate, which is going on. For that, I have also challenged. I filed a title suit against my brother. That without the partition, he has sold off the property to the defendant itself. For that, another suit is going.
That is not the question of law.
It's not that, but it is that
We will not go
there was
beyond.
no
See, you
partition.
cannot make out a new case here.
So I am not picking up, my lord. It's rest
You
with us.
are making out a new case.
But my lord, only point.
Merely because there is some admitted fact, we
Issue
will
has
not
not been-
permit.
It may be issue.
No.
Oh, one
Whatever
last-
has been framed by the question of law, we will confine only to that. We can't go on like this. The matter was remanded after framing two issues, and then it was decided, isn't it? So you have not raised whatever you are saying. Now we are not going to go through the plaint and the written
But
statement
that
and
is
find
covered
out.
by the judgment, my lord. That has been covered by the judgment of this court. 2016 and 2019 is covered, which goes against me. One last argument, if my lordship will permit me to make, which I had raised in the morning also, my lord, that the prayer which I had made for the
That we
position.
will not permit. There is a specific question of law for it. We are not going to permit. We are not going to permit you to go outside whatever it
That
is.
my case is rested by the 2019 and 16 judgment, my lord, which goes against me. Only it can be remanded back if your lordship.
For what?
Because the issue was not framed by both the courts. The
We are
position
not
is.
going- We are not going to enter into it. We will decide only whatever. ये जो 2019 वाला judgment. What was the 2019 judgment?
My lord, it is 2019.
You have a copy? Judgment.
No, my lord, I don't have the copy. I have on the.
Furnish the copy.
That
What was it?
2019 20 SEC 633.
ये जरा दीजिए। डेट मंगाई थी 20 SEC 633 गोराई जी को बोलिए दे। Which paragraph?
Now the paras are para 21, 28, para 23 to 27 is also relevant.
This is on the point.
This is on the point which says that whether the provisions of 8.2 is not followed, then it's voidable, and
Alright.
Article 60 comes into play. Within 3 years you have to do. And 16 judgment also, my lord, that is also there.
Yes. Where is the order of remand? इसका record है ना? Order of remand, which two issues were framed by virtue of the order of remand?
That has not been annexed, my lord. That I.
In the memo copy, I have stated before the court below that the suit filed by the before the municipal section was dismissed by order dated 31st March 1995, which the respondent preferred an appeal against that, and the appellate court in title appeal number 9 of 95, and it was allowed and remanded back to the Jharkhand court below after framing two issues.
Which
By
issues?
issue.
बताइए कहाँ है two issues?
Issues कौन सा था?
मिला क्या? What were the two issues? Who is Jalil?
Jaila.
Jaila?
Jaila is my lord, the father of the. Jaila is the.
Father of the defendant?
Jaila is Karmu's plaintiff's grandfather.
Plaintiff का grandfather. मंगू का grandfather. मंगू का father. बंधु का father कर्मू. कर्मू. कर्मू का father. Grandfather.
In the suit, the brothers of the plaintiff were also party. Who were party in the suit?
Yes, brother of the plaintiff was also one of the party. Defendant number 2 was the brother of the plaintiff, Mangu.
Issue number Romans 8 is in the trial court judgment that there was no partition between 5 brothers and therefore there was no question of exclusive possession of the property by Joyla.
Which has been that in page 20 of my issue number 7.
Yes, yes. Issue number 8.
8 but वो judgment में हमारा 7 कर दिया उसको. Whether on perusal of the case record it
Yes,
appears
yes.
that there was no partition.
It was the case of the plaintiff only that the partition had taken place.
Till the father.
Yes,
But after the father's death, the legal heirs of the father, no partition has been taken place.
that's right. देखिए, about the learned counsels appearing on behalf of the parties. This appeal has been admitted on 24/9. आपको कुछ बोलना है? You want to say anything? I've not heard
The
it.
sale was valid in view of the decision of the
दे दीजिए
Report.
बच्चा.
2016 Supreme Court. AR 2016 Supreme Court, page 1666.
कहाँ है judgment? एक तो है.
Narayan
Which paragraph are you relying that suit is valid, that sale was valid and without any?
Para 29 to 32. So, dealt with Article 60.
Para 25 पढ़िए.
25 to
पढ़िए para
29 to 32.
You read para 20.
29.
25.
29. Not
But-
bad by me.
25, 24 से पढ़िए.
We do not consider the necessity of extracting the particular provision relied upon by the land council for the leaseholders. We are satisfied in accepting the contention that the terms renewal has been rejected. The
ये क्या
determination
पढ़ रहे हैं आप? Para 24.
24
Renewal of lease क्या पढ़ रहे हैं?
24 में तो वही है 29 में हम बोल रहे थे
24 से पढ़िए.
पैरा 20
Para 24 of your judgment which you have cited.
पैरा 24 तो वही हम पढ़ रहे थे
When one's transaction takes place in the name of minor.
SCC
Well, should I read it?
Yes, please.
When once a transaction takes place in the name of the minor, which is in contravention of the 1956 Act and which is not done for legal necessity, such transaction is voidable, and unless such a transaction is sought to be impeached or set aside, the question of recovery of possession of that property does not arise. Para 25, a close analysis of the language of Article 60 would indicate that it applies to suits by a minor who has attained majority and further by his legal representatives when he dies after attaining majority or from the death of the minor. The broad spectrum of the nature of the suit is for setting aside the transfer of immovable property made by a guardian and consequently a suit of possession by avoiding the transfer by a guardian in violation of section 8(2) of 1956 Act. In essence, it is nothing more than seeking to set aside the transfer and grant consequential relief of possession. May I read para 26? Para 26, there cannot be any doubt that a suit by condom minor to set aside the alienation of his property by the guardian is governed by Article 60. To impeach the transfer of immovable property by the guardian, the minor must file the suit within the prescribed period of 3 years after attaining majority. Para 27, the Limitation Act neither confers a right nor any obligation to file a suit if no such right exists under the substantive law. It only provides a period of limitation for filing the suit. Hence, we are of the considered opinion that the minor plaintiff challenging the transfer of an immovable property made by his guardian in contravention of Section 8(1) and 2 of the 1956 Act and who seeks possession of property can file the suit only within the limitation prescribed under Article 60 of the Act and Article 109, 110 or 113 of the Act are not applicable to the fact of this case. The High Court as well as the Trial Court erred in applying Article 109 of the Act, where Article 109 of the Act clearly speaks about alienation made by father governed by Miktakshara law, and further courts below proceeded in discussing about the long route given under Article 109 of the Act, and comparatively lesser times specified under Article 60 of the Act. It is well settled principle of interpretation that inconvenience and hardship to a person will not be a decisive factor while interpreting the provision. When bare reading of the provision makes it very clear and unequivocally gives a meaning, it was to be interpreted in the same sense as the Latin maxim says, "Tulo lex sed lex," which means the law is hard, but it is law, and there cannot be any departure from the words of law. Hence, in view of the above discussion, the limitation to file the present suit is governed by Article 60 of the Act, and the limitation is 3 years from the date of attaining majority. When once we arrive at a conclusion that Article 60 of this Act applies and the limitation is 3 years, the crucial question is when there are several plaintiffs, what is the reckoning date of limitation? A reading of Section 7 makes it clear that when one of the several persons who are jointly entitled to institute a suit or make an application for the execution of the decree and a discharge can be given without the concurrence of such person, time will not run against all of them, but when no such discharge can be given, time will not run against all of them until one of them becomes capable of giving discharge. In the case on hand, the first plaintiff was 20 years old and the second plaintiff was still a minor, and the plaintiff 3, 4 and 5 who are married daughters were aged 29, 27 and 25 respectively. On the date of the institution of the suit in the year 1989, as per explanation 2 of the Section 7, the manager of a Hindu undivided family governed by Mitakshara law shall be deemed to be capable of giving a discharge without concurrence of other members of the family only if he is in the management of the joint family property. In this case, plaintiff 3 to 5 so measures as on the date of institution of suit will not fall under explanation 2 of Section 7 of the Limitation Act, as they are not the managers or karta of the joint family. The first plaintiff was 20 years old as on the date of institution of the suit, and there is no evidence forthcoming to arrive.
That's right. Okay, heard the learned counsel appearing on behalf of the parties. This appeal has been filed against the judgment and decree dated 15 February 2017 passed by learned District Judge Roman 8, Dhanbad, entitled Appeal number 38 of 2011. Whereby the first appellate court has been pleased to allow the appeal preferred by the respondent and has set aside the judgment and decree dated 31/3/2011, within bracket decree signed on 18/4/2011, passed by learned Sub-Judge Roman 6 Dhanbad, entitled suit number 174 of 1988. The learned Sub-Judge has decreed the suit filed by the plaintiff, within bracket Appellate hearing, and the decree has been set aside. This appeal was admitted on 24/9/2018 to be heard on following substantial questions of law. The learned counsel for the appellant has submitted that the suit was filed in connection with plot the case of the plaintiff in short was that suit plot under Moza Kanchanpur was situated under Khata number 38, plot number 1184, area 54 decimal, which was recorded in the name of Dukhi Mehto and his 4 brothers having equal share. And it was partitioned amongst the brothers it was pleaded during the course of trial that the suit property was partitioned amongst the brothers, but at the same time it was pleaded in paragraph 4 of the plaint that the recorded tenant Kanhai did not take his share in plot number 1184, while other brothers got their 1/4 share. As such, all the 4 brothers were having 13.5 decimal of land. It was further pleaded that Dukhi Mehto died leaving behind 3 sons, namely Hiralal, Govind and Jailal, and partition took place amongst Hiralal, Govind and Jailal. After partition, 13.5 decimal of suit property came in exclusive share of Jailal. Subsequently, Jailal died, leaving behind his only son Karmu and wife Sonia. Karmu constructed a house on the western side of the suit plot, measuring 8 yards in length and 1/5 yard in breadth, with a kotha on it, and lived with his family consisting of his two sons, Mangru and Bandru, and his wife Sonia. At the relevant point of time, Bandru was hardly aged 2 years when his father died, and the plaintiff's mother Sonia died around 10 years ago from the date of the plaint. And the plaintiff at the relevant point of time, at the time of filing the plaint, was about 23 years of age, and he attained the age of majority in 1986 and was living in a portion of the said house. And his brother Mangru was living in the adjoining room. It was also pleaded that the defendant number 1 in the last week of November threatened the plaintiff to hand over vacant possession of the house and defendant number 2 had sold his share in the land as well as the house to defendant number 1 as in the March of 1983, and the defendant number 1 also disclosed to the plaintiff that the mother of Sonia during the minority of the plaintiff had sold his share on 15/6/1973 through a registered sale deed. And consequently, the plaintiff came to know about the registered sale deed executed by his mother on 15/6/1973 when he was minor. He obtained certified copy of the deed executed by his brother Mangru Mehto on 13/3/1973 and asserted that a false recital was made that the plaintiff's brother was namely defendant number 2 was the owner to the extent of 8 decimal of land of plot number 1184, khata number 38, and purported to sell his half of the room. It was a case of the plaintiff as to how Mangru Mehto, the defendant number 2, could get 8 decimal of land when admittedly Karmu died leaving behind 3 heirs, namely his widow Sonia, son Mangru Mehto and the plaintiff Bandru Mehto. He stated that after partition, in the manner stated, Karmu had only 1/4 share of total area of 54 decimal, that is to say 13.5 decimal of land, and consequently Mangru would inherit only and consequently Mangru could inherit only 4 and 5/16th, although he had executed a sale deed to the extent of 8 decimal of land. It was pleaded that the plaintiff, that the purported sale deed executed by his mother as guardian of the plaintiff be set aside, and following prayers was made. The plaintiff had applied for cancellation of sale deed number 14222 dated 15/6/1973, executed by plaintiff's mother to defendant number 1. And the plaintiff also sought declaration of half share over the area of 8.14 decimal, being the western side of plot number 1184 described in the schedule. The plaintiff also sought for confirmation of possession and alternatively, if the plaintiff is found to have been dispossessed, for the recovery of possession. The plaintiff also sought a decree of permanent injunction against the defendants. The defendants had appeared and opposed the suit. It was denied that the plaintiff had attained the age of majority only in the year 1986. It was also pleaded that while in possession, Mangru sold 8 decimal of land in plot number 1184 out of the land possessed by him, together with structure and boundary, by registered deed dated 13/3/1973 and put the defendant number 1 in possession thereof. And similarly, Sonia, acting for herself and her minor son, being in urgent necessity for meeting family expenses, sold 4 decimal of land in plot number 1184, including the structure for valuable consideration, by registered deed of sale dated 15/6/73, in presence of Mangru Mehto, and she had put the defendant in possession. The learned counsel has submitted that altogether 7 issues were framed, including the point of limitation. And also the point as to whether the plaintiff was entitled for a decree of cancellation of sale deed dated 15/6/73, and further whether mother of the plaintiff was entitled to execute the sale deed for her minor son without the permission of the court, and whether the sale deed executed in favor of defendant number 1 was void ab initio. The learned counsel for the appellant has submitted that while deciding issue number 7 in paragraph 25, it was held that it was recorded that it was admitted by the defendant number 1 that the property of khata number 38, plot number 1184 was never partitioned between the 5 brothers, and therefore there was no question, and therefore no question arose that the suit property had come in exclusive share of Joyla. so far as the point of limitation is concerned, the same was decided by para number 26 of the trial court judgment. And it was held that the transfer of minors property by de facto guardian and without legal necessity was void ab initio, and hence it was not required to be set aside within 3 years from attaining his majority, and the learned trial court held that the suit was not barred by limitation. The learned trial court also held that the plaintiff had valid cause of action, and it was found that the suit was maintainable and the plaintiff was entitled to get the relief as claimed in the suit. The suit was decreed on contest. The registered sale deed number 14222 dated 15/6/73 executed by Sonia was declared to be void ab initio, and the sale deed was declared to be null and void. And the right title and possession of due share of the plaintiff described in Schedule A of the plaint was restored. The appellate court determined the following points for consideration. Paragraph 13. By deciding point number 1, 2 and 3, the appellate court recorded that it was admitted by the parties that there was partition amongst the 5 brothers, and each got, and one of the brother did not take his share, and it was divided into 4 equal shares consisting of 13.5 decimal each. Dukhi Mehto died leaving behind 3 sons, Hindu, Govinda and Jaila. This was also not denied by the defendants, and the suit property measuring 13.5 decimal fell in the exclusive share of Jaila, who died leaving behind only son Karmu, and Karmu died leaving behind 2 sons, plaintiff and Mangu and widow Sonia. The learned court held that the sale deed executed by the mother of the plaintiff in favor of defendant number 1 was the learned court considered the argument that the sale deed executed by the mother of the plaintiff was void ab initio, and by referring to the judgment passed by Honorable Supreme Court in the case of Narayan versus Baba Sahab, reported in AIR 2016 within that SC 11666. Wherein it was, and also referred to the judgment passed by the Honorable Supreme Court, Narayan versus Baba Sahab, wherein it was held that that once the transaction takes place in the name of minor in contravention of section of 1956 Act and was not done for legal necessity, such a transaction is voidable. And unless such a transaction is sought to be impeached or set aside, the question of recovery or possession of that property does not arise. And to impeach the transfer of immovable property, the minor has to file the suit within a period of 3 years after attaining majority. The appellate court held that the suit was filed after 3 years from the date of attaining majority, and therefore the suit itself seeking setting aside of the sale deed dated 15/6/1973 was barred by limitation. And therefore the plaintiff was not entitled for cancellation of the sale deed dated 15/6/1973. With regard to the declaration of share of the plaintiff, the learned court, by deciding point number 4, recorded that the plaintiff himself has said that Mangu Mehto, that 8 decimil of land was sold by Mangu Mehto, his elder brother, through a registered deed of sale exhibit 3, which was not set aside till the date of the judgment. And the plaintiff had brought the suit for cancellation of sale deed by his mother to the extent of 4 decimil of land. The learned appellate court, by deciding point number 4, recorded that the plaintiff has got no right, title and possession over the suit land, and also referred to the documents on record, that is exhibit A series, B series and D/1, from which is transpired that the defendant number 1 was in possession of the suit land. The learned appellate court held that the plaintiff was not entitled to half share of the suit property as claimed, and point number 4 was also decided against the plaintiff. The learned court ultimately allowed the appeal and set aside the judgment and decree. The learned counsel for the appellant, by assailing the judgment passed by the learned appellate court, has submitted that there was no partition amongst he and his brother.
And the mother at that time.
He and his mother and the
Brother
he
dependent.
and his brother and also the mother at any point of time. Okay? And therefore, it could not be said that and therefore it was only undivided portion of the property which was sold by the mother. He has submitted that this aspect of the matter has not been taken care of by the learned appellate court. And therefore, the property being joint family property,
Yes.
the parties would be governed by Article 59 of the Indian Limitation Act and not by Article 60. And the point of limitation would commence from the date of knowledge. This is your case. On the other hand, the learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that and has relied upon the judgment passed by the Honorable Supreme Court in the case of Narayan versus Baba Saheb, reported in bracket 2016 bracket 26 SCC 725. And has submitted that the learned appellate court has rightly held that the suit was barred by limitation. And he has submitted that he has referred to paragraph 24 to 29. Of the state judgment. The defendant number 2 did not file written statement, yes. He did not file written statement.
He did not. No, no. It was not filed.
इन्हीं के appellant के submission में नहीं किया. The learned counsel for the appellant has also submitted that the defendant number 2 did not file the written statement and accordingly did not contest the suit. Contest भी नहीं किया, written statement ही नहीं फाइल किया तो क्या ही contest करेंगे? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the foundational pleadings and the findings recorded by the learned trial court and the appellate court has already been narrated by, placed by the learned counsel appearing on behalf of the appellant, which has already been recorded above. This court finds that the issue essentially arises with respect to interpretation of Article 60 and 109 of the Limitation Act as well as Section 8 of the Hindu Minority and Guardianship Act, which has been referred to in the substantial question of law as framed by this court on 24/9/2018. This court finds that admittedly the property involved in the present case was transferred by the mother of the plaintiff in favor of the defendant number one without obtaining the required permission from the deputy commissioner,
From the court.
from the court, while the plaintiff was minor and the suit was filed after expiry of 3 years from the date the plaintiff attained majority. The trial court held that the sale deed was void ab initio and consequently held that the suit was not barred by limitation. The appellate court held that the sale deed was voidable and referred to Article 60 of the Limitation Act to hold that the suit was barred by limitation. So far as the applicability of Section 109 of the Article 109 of the Limitation Act is concerned, the same does not come into play in view of the fact that it deals with alienation it deals with limitation for suit by a Hindu governed by Mitakshara law to set aside his father's alienation of ancestral property. In the present case, the alienation is by the mother of the plaintiff, and therefore the said article does not have any applicability. Article 60 of the Limitation Act clearly provides for the limitation with regard to prayer to set aside a transfer of property made by guardian of the ward, which is 3 years from the date when the ward attains majority. The Honorable Supreme Court in the case reported in bracket 2019 bracket close 20 SCC 633. And also in the judgment reported in bracket 2016 bracket close 6 SCC 725 has held that sale in contravention of section 8(2) is voidable. And the point of limitation would be 3 years from the date the minor attains majority. This court is of the view that the appellate court has rightly referred to section 60 of the Limitation Act to hold that the suit was barred by limitation. As particularly in view of the fact that the sale was voidable and not void ab initio. This court further finds that the appellate court, after considering the materials, recorded that the defendant number 1 was in possession of the suit land. And that the plaintiff was not entitled for half share of the suit property as claimed. The appellate court also recorded that 8 dismil of land in plot number 1184 was already sold by the elder brother of the plaintiff, who was defendant number 2 in the case, through a registered sale deed. Until the date of passing of the appellate court's judgment, the sale deed was not set aside. This court is of the view that the learned appellate court rightly decided point number 2 as well as point number 3 by holding that the sale deed dated 15/6/73 was neither void ab initio nor the plaintiff was entitled for a degree of cancellation of the sale deed, as the suit was barred by limitation. This court is of the view that the learned appellate court has rightly decided the aforesaid issue and rightly interpreted the provisions of Article 60 and 109 of the Limitation Act, as well as Section 108 and Section 8 of the Hindu Minority and Guardianship Act. The question of law framed by this court by the order dated 24/9/2018 is is accordingly decided against the appellant and in favor of the respondent. Consequently, the present appeal is hereby dismissed.
Pleasure.
There will be corrections. A video recording में prove के बैठे हैं. There will be corrections, right? I may add a few judgment also.
Password to item 50, second appeal 5 of 2023.
The plaintiff have filed a suit for a specific purpose in 2006. The suit was filed on 7/6/2006. For a specific performance of contract, there is an agreement between the parties, the defendant, in favor of defendant by the defendant, in favor of the plaintiff, for taking advance and having an agreement for sale with respect to a plot, that is the suit. This agreement was 22nd of September 2005. September 2005. On that strength, the suit was filed because according to plaintiff, the defendant failed to perform their part and they were willing and ready to execute their part. And therefore,
You were the buyer, you are the plaintiff,
I am the defendant.
appellant is the defendant.
Appellants are defendant. It is the suit appeal. It is the case of reversal. The suit was dismissed. The plaintiff preferred an appeal. First appeal that has been allowed,
That's right.
and therefore, my lord,
Why
before
was
you.
the suit dismissed?
The suit was dismissed, my lord, because the finding of the trial court that this is not a partition suit. The jointness of the family is not proved by the plaintiff. Unless and until the partition has been proved by the plaintiff, the agreement of a specific portion of joint family property could not be agreement for sale. Therefore, the agreement is void and not executable, and being a discretionary power under section 16 of a specific performance act, the trial court said it is not enforceable, therefore the suit has been dismissed.
The suit, there was a finding that it is a joint family property.
Yes, but while deciding this issue, since it was a specific performance of my lord, therefore the question of partition was not raised. Rather, some pleading were in the plain. But the appellate court reversed the finding of the trial court on the basis that it is the partition was by meets and bounds, and the exhibit X was identification has been marked, and on the strength of that exhibit, the appellate court said, no, the executant of the agreement, defendant number one, has a exclusive ownership of the concerned property,
Property was standing in whose name?
the jointness of the family,
No.
the defendant also,
Was it standing in the name of all the persons?
all the persons, though the case was that it was lottery was made among the parties and it was for convenience, if they are maintaining the property. This was the
No, property must be sold
jointly.
jointly. From where do I get this?
My lord, your lordship, from that judgment, your lordship will get from trial court judgment itself. Page 40 of this document. Finding is at page 46. I'm just relevant part. I'm just reading. Therefore, thereafter I will elaborate more. Page 46. If your lordship may kindly say. Trial court internal page 7. Is finding paragraph 5. Issue number 6. Whether the agreement for sale dated 6th of September 2005 executed by the defendant in favor of the plaintiff is valid and genuine. This was the issue. For the sake of convenience, this issue is taken first for determination. On perusal of the plain, it transpires that the land and house standing over holding number such and such, what number so and so, area measuring section, by the father of defendant number 1 and the name of the mother of defendant number 1, Srimati Bima Devi, who died leaving behind 7 sons, so and so, so and so, so and so. The defendant is my lord Kishori Prasad Gupta. The plaintiff further stated that aforesaid 7 brothers amicably partitioned the aforesaid land and building along with land, house and properties, particularly at Mohalla Dariyadi, and said partition got reduced into writing by virtue of deed of family arrangement partition dated 17/2/95, duly signed by all the brothers, and the suit property fell into fall exclusive share of the Kishori Prasad Gupta, whose name was duly notated in Giridi municipality, and defendant number 1, Kishori Prasad Gupta, is the absolute owner of the suit property, having right title and interest to alienate or transfer the same. If through his father, Ravindra Prasad Gupta, is running a grocery shop in the portion of the suit premises measuring 4 feet 24 3 feet, along with that, the portion of the belonging to the Umesh Prasad Gupta, measuring 8 feet by 23 feet since 1982, was a tenant under the father of defendant number 1, and thereafter, under the defendants, the rents were being paid to them. In September 2005, the defendant was in need of a heavy amount for the purpose of business, and he approached to offer the plaintiff to sell the suit premises in consideration of 14 lakhs 11,000, and accordingly entered into agreement dated, registered agreement dated 6/9/2005. And plaintiff paid rupees 2 lakh to the defendant number 1, Kishori Prasad Gupta. Kishore Prasad Gupta.
How does it, from where does it come to a finding? Where is the finding that it is not a joint family
वो
property?
छोटा सा है इसलिए हम
वो
पढ़
एक लाइन का फाइंडिंग है, लेकिन उसमें जॉइंट फैमिली है कि नहीं है इसके बारे में क्या है डिस्कशन?
नहीं कुछ है इसीलिए हम बोल रहे थे मान लो पेज 48 फाइंडिंग इज देयर
हाँ वो तो पेज 47 से ही लास्ट लाइन
हाँ,
में
page
शुरू
47
है.
के
Considering
last
oral statement and documentary evidence
हाँ,
of the
बस.
plaintiff, I find that the property is a joint family property.
यस
इसका क्या बेसिस है?
तो ये स्पेसिफिक परफॉर्मेंस जॉइंटनेस का तो डिसाइड हो नहीं सकता
नहीं जॉइंटनेस का इसलिए डिसाइड करना जरूरी था
इंसिडेंटली
इंसिडेंटली, क्योंकि अगर जॉइंट फैमिली है तो सभी को जॉइंटली उसको एग्रीमेंट करना,
यस
ठीक है?
ये एक्सक्लूसिव कर दिए
But the point is that as per the plaintiff,
Yes.
there was a partition by Mitzenbaum.
अकॉर्डिंग टू प्लेंटिफ
They came in exclusive possession of the property
Yes.
after partition,
यस
right? And in fact, the father of the plaintiff was also a tenant.
पैरा 7 देखिए उसमें
हाँ,
पैरा 7 पेज 48 का ये
page 48.
जी पैरा 7 on going through the evidence of PW1 and 3 I find that the suit property is joint properties. Partition has not been proved by the plaintiff, nor any registered paper of
Not
partition.
required. Not required. Roshan Singh versus Vijay Singh.
This fact has been considered in the two more fact is important before I can
For a
proceed.
partition in Hindu family,
Yes.
if there is a partition by meet and bound,
It is not by needs and wants. It is by convenience, for the sake of
Maybe by convenience,
For
if
arranging.
if there is a oral partition amongst them, which is subsequently reduced in writing,
Yes.
that is a valid
Must be
partition.
registered.
Not registration not required. Roshan Singh versus Dilip Singh.
My
खुद
lord,
ये जजमेंट लेके
There are two parts.
कॉलेज में पढ़े थे, अभी याद है.
हाँ, हमको भी याद है. हम
Privilege-
इसीलिए बता रहे
Privilege
हैं.
settlement does not require registration.
88 सुप्रीम कोर्ट भी इसको डिसाइड किया. हम ये कहना चाह रहे थे कि the agreement which is in question, that agreement is dated 6th of September 2005.
6 September 2005.
Filed, and the suit was filed on 7th of June 2006.
7/6/2006.
6. On 22nd of February 2006, this agreement was revoked.
22.
22nd, yes, 22 फरवरी 2006.
Revoked by whom?
By the defendant itself, the executed. And one more fact, just
Revoked?
Give me only 2 minutes further.
Yes.
My lord, there is another agreement that is prior to this. What is the date? 22/5/2005. May 2005. There was an agreement, and the power of attorney was there, and on that strength, a sale deed was executed. That is HSC. That is of 2005 May 2005. The same property was earlier sold by the defendant.
Which defendant?
The defendant Kishore Prasad. And thereafter, this agreement in question, the plaintiff has filed the suit without cancellation of that sale deed, because that is prior to this sale deed, this agreement. Therefore,
What is the date of sale?
that sale deed. Yes.
इस सीक्वेंस को ठीक करिए, ठीक है. 22/5/2005 को फर्स्ट एग्रीमेंट हुआ.
जी.
बिटवीन बताइए.
First agreement
Between
between the defendant number 1 and the plaintiff.
defendant number 1 and plaintiff. Okay. All right. उसके बाद
सितंबर का पूछ
6/9/2005 को क्या हुआ? सेकेंड एग्रीमेंट की क्यों जरूरत है?
हाँ, सेकेंड एग्रीमेंट 2000 सितंबर
ये
का
किसके बीच में हुआ?
सितंबर 2009 में सितंबर
किसके बीच में हुआ?
सितंबर 2006 में जो एग्रीमेंट हुआ वो
2005
नहीं,
सितंबर में मेरे साथ
नहीं, 6/9/2005 आपने बताया.
हाँ, सितंबर
2005
2005 वो सेकेंड एग्रीमेंट
किसके बीच में?
प्लेंटिफ एंड डिफेंडेंट.
डिफेंडेंट नंबर
पहला एग्रीमेंट है 6/5/2005 को.
आप 22/5 बोले, 6/5 लिखते हैं उसको. ठीक है, 6/5
6/5/2005
को पहला
पहला
एग्रीमेंट.
एग्रीमेंट
तो
हुआ.
दूसरे की क्यों जरूरत पड़ी?
हाँ, इसलिए बता रहे हैं लोग, यही इसीलिए क्रिमिनल केस भी किए थे हम पर.
क्रिमिनल केस से इसका क्या ही लेना देना?
वो दूसरा
आप
एग्रीमेंट
अपनी
तो
ये-
गलत है. पहला
नहीं, कोई जरूरत, कोई
हाँ, नहीं,
बिना
कोई जरूरत
कारण
नहीं
के
था.
कोई डॉक्यूमेंट नहीं बनता है ना.
कोई जरूरत नहीं था. क्यों कि ये आपस में कहीं मिसअंडरस्टैंडिंग हुई है.
ये
किसी-
टाइम बाद हो रहा होगा, इसीलिए फ्रेश एग्रीमेंट हो गया होगा.
नहीं, ये राज पार्टी है.
अच्छा,
ये
कौन सा
परिवार में है. ये
कौन
एग्रीमेंट परिवार का था पहला.
अच्छा,
भाई जो है अपने दूसरे भाई के वाइफ को बेचे है, उसके लिए एग्रीमेंट था इंटर फैमिली.
अच्छा, इट
और
इज
वो रजिस्टर्ड सेल्ड हुआ
तो
है.
प्लेंटिफ और डिफेंड नंबर 1
Plaintiff
ये
नहीं.
दोनों सेम पार्ट, सेम फैमिली के हैं.
डिफेंडेंट 1 एंड डिफेंडेंट 2 इनके बीच में एक सेल हुआ था जो
नहीं, ये जो एग्रीमेंट आप तो डिफेंडेंट नंबर 1 एंड प्लेंटिफ बोल रहे हैं,
वो
दोनों
तो
में बोल रहे हैं प्लेंटिफ एंड डिफेंडेंट नंबर 1.
दूसरा का है.
हम नहीं जानते भाई. आप हमको इस सूट प्रॉपर्टी से रिलेटेड जो भी एग्रीमेंट है और किसके किसके बीच हुआ है बताइए.
पहला एग्रीमेंट है 6/5/2005 का.
किसके बीच में? नाम बता दीजिए अगर डॉक्यूमेंट आपके पास है तो.
किशोर has executed the agreement with Madan Prasad Gupta.
किशोर इज
Kishore is defendant number 1.
डिफेंडेंट 1
Yes.
विद मदन.
Madan, who is defendant number 3.
तो आपका ये तो स्टेटमेंट ही गलत है कि डिफेंडेंट नंबर 1 एंड प्लेंटिफ के बीच में हुआ था।
सेकेंड वाला
अच्छा ठीक है, ये डिफेंडेंट नंबर 1 एंड 3 के बीच में एग्रीमेंट है 6/5/2005।
जी, और उसके आधार पर सैलरी डिस्प्यूट हो गया
कब?
जी 2005 माय लॉर्ड 2005 में एक सैलरी डिस्प्यूट होता है, हम वो डेट दे रहे हैं, और उसके बाद ये दूसरा एग्रीमेंट हुआ है जो स्पेसिफिक परफॉर्मेंस के लिए सूट हुआ है, जो प्लेंटिफ
6/9/2005 6/9/2005।
6/9/2005।
तो इसी पहला वाला एग्रीमेंट का डेट ऑफ सेल बताइए ना।
हाँ, डेट ऑफ सेल है 29/5/2006। आई हैव द डीड कॉपी 29/5/2006
डेट ऑफ सेल
on the strength of the earlier agreement. जी जी
29/5/2006,
जी,
1 साल से भी ज्यादा के बाद।
हाँ 3 साल का एग्रीमेंट का वैलिडिटी।
हाँ
3 साल का agreement।
ऐसा नहीं होता ना, एग्रीमेंट में टाइमलाइन रहता है कि 3 महीना में
हाँ,
करेंगे,
तो
1
उसके
महीना
बाद-
में करेंगे,
उसके बाद पैसा देंगे तो एक्नॉलेज होगा तो एक्सेप्ट करेंगे।
उसके बाद नहीं, इतना दिन में पैसा देंगे तब एक्नॉलेज करेंगे तब एग्रीमेंट करेंगे।
तो इस केस में जो प्लेंटिफ का केस है उसमें इनका कहना है कि हम देने के लिए तैयार थे, हम लेने के लिए नहीं। देयरफॉर दी फाइल ए स्पेसिफिक परफॉर्मेंस।
भाई ये वाला सूट जो है 6/9/2005 का स्पेसिफिक एग्रीमेंट से रिलेटेड
जी,
है,
बस उसी
ठीक
से
है।
related।
और ये जो 29 सूट का फाइल हुआ बताएं।
सूट फाइल हुआ था 7 जून 2006 को।
7 जून 2006 सूट फाइल हुआ।
जी,
इसमें इसका इस सेल डीड का सेटिंग असाइड का प्रेयर नहीं था।
नहीं। और ये आया भी है जजमेंट। अब स्पेसिफिक परफॉर्मेंस का अगर सूट है तो दैट इज ए डिस्क्रिशनरी पावर योर लॉर्डशिप इज वेल अवेयर माय। सो वेदर द ट्रायल कोर्ट्स फाइंडिंग कैन बी सेट असाइड बाय द appellate court on deciding the issue of partition।
इश्यू ऑफ पार्टीशन इसलिए रेलेवेंट है क्योंकि अगर पार्टीशन नहीं हुआ देन अंडर सच सर्कमस्टांसेस देयर वाज नो स्कोप फॉर एंटरिंग इनटू एग्रीमेंट डेटेड 6/9/2005। ठीक है, इसीलिए इश्यू ऑफ पार्टीशन आया। ठीक है,
तो मेरा
अब ट्रायल कोर्ट ने बोल दिया कि पार्टीशन नहीं हुआ क्योंकि रजिस्टर्ड डीड नहीं। एपेलेट कोर्ट ने बोल दिया कि पार्टीशन है। अगर पार्टीशन हुआ
they have treated it as a partition।
they have treated it as a
Yes।
partition। अगर पार्टीशन हुआ then under such circumstances the agreement dated 6/9/2005 is a valid agreement।
Yes, subject to proof of the partition। It
Yes,
is not
subject-
inference
proof of partition
because वो exhibit भी नहीं आया।
certainly भाई appellate court तो बोल दिया कि पार्टीशन हो गया।
हाँ, ठीक है।
ठीक है।
Therefore we are before a lordship whether the finding of the appellate court is based on any evidence pleading, because any evidence given not made in the pleading cannot be admissible।
So it is there was a oral partition, it was
Even oral
subsequently
partition can be accepted to the extent।
yes,
I-
तो वो
I
ही
know
एक्सेप्ट
this।
किया है ना इशू नंबर 6 में, उसी को एक्सेप्ट किया है।
Trial
there
court-
was a pleading,
trial
there was
court-
an evidence,
trial
yes,
court का, yes, and what is the finding
नहीं
of that?
एक्सेप्ट रिकॉर्ड किया है लेकिन उसके बाद बोला कि रजिस्टर्ड नहीं है तो हमने ले।
और वो सेल डीड भी चैलेंज नहीं हुआ। दिस इज अनदर ग्राउंड दैट सेल डीड वाज नॉट अंडर चैलेंज बिकॉज दैट हैज टू आउट फ्रॉम, बिकॉज दैट इज एन इम्पेडिमेंट फॉर हैविंग ए डिग्री ऑफ स्पेसिफिक परफॉर्मेंस। So that point and
That sale deed was also executed by the defendant number 1.
Yes, and therefore your lordship the substantial।
Yes, did you challenge the sale deed?
No.
Why?
My lord, just a minute.
Not required to be challenged.
Their contention is two. One is there is no previous partition. Had that
आप मान लेते हैं पार्टीशन है, भूल जाइए पार्टीशन का। आप हमको ये बताइए जो सब्सिक्वेंट सेल डीड हुआ आफ्टर योर एग्रीमेंट इन फेवर ऑफ बिटवीन डिफेंडेंट नंबर 1 and 3,
yes,
right? You have not challenged it in your suit when you are seeking specific performance.
yes,
So you are asking the defendant number 1 to register two sale deeds with respect to the same property. One is already executed, the other you want through specific performance. कैसे हो?
And therefore,
Well,
first
it
question
is
of
the
substance.
sale deed executed by defendant number 1 in favor of defendant number 3.
हाँ.
That was not within my knowledge at any
Where-
point of time.
No, it must have been exhibited.
Much during the pendency of the suit.
Why didn't you file your amendment? Amendment was required, judgment है. Amendment is required to be filed.
My lord, I am coming to the other point.
यही तो
The-
एकमात्र point है, बाकी क्या है?
while admitting, there are two substantial questions of law. While admitting the second appeal, I am reading both the substances.
Okay.
Whether the appellate court committed perversity by decreeing the suit of the plaintiff, even though as the plaintiff knowing pretty well that the defendant number 1 has sold the suit property to the defendant number 2, while registered sale deed dated 29/5/2006,
Yes.
marked at Exhibit C,
Ah.
yet did not pray for cancellation of the. This is the first.
Yes.
The second is.
ये पहला फर्स्ट में ही रही है ना?
हम
अगर ये
second
चीज
से first में आ रहे हैं.
सेकंड से फर्स्ट पे आएंगे.
Whether the suit property being a joint family property, had it been the joint family property, then there is no question of.
No, there is a finding of the appellate court that it is not a joint family property.
If that is admitted, then the second question.
आप बस ये पहला पे ही सारा कहानी. पहला
It was not needed me.
कहाँ से बोल रहे हैं? Let us assume that it was not within your knowledge, but it was exhibited during trial.
Yes.
Did you challenge it?
No, I.
Then
But
एक ही प्रॉपर्टी का दो सेल डीड एक आदमी कैसे करे?
it is the defendant number 1 himself is to decide.
So what? आप उसको क्रिमिनल केस कर दीजिए, जो कर दीजिए, नया सेल डीड तो नहीं करवा पाइएगा उससे.
I need not to reply.
Sorry.
Because I am reading para.
Do you want to say that this particular exhibit C is null and void?
Null and void means this has been prepared later on the basis
लेटर ऑन मतलब क्या? भाई आपका सूट फाइल करने के पहले ये डीड एग्जीक्यूट हो चुका है, रजिस्टर्ड डीड है, द डेट कैन नॉट बी डिस्प्यूटेड. It has already been executed on 29/5/2006. Could be that it is not within your knowledge. Let us assume for a moment, and you had filed your suit for specific performance. But during the trial, it came to light that there is already a sale deed in connection with this property. And unless that particular sale deed is set aside, where is the question of decreeing for specific performance?
after getting the sale deed executed in favor of defendant number 3, whether at any point of time they have asked to vacate or because I was the tenant there
Need
and the
not.
property has been and I have not paid the rent to the
You
defendant
forget
number
about your
3.
tenancy. We are not bothered
Therefore,
about.
that sale deed is not came into force.
We are no. कैसे?
The sale deed. of
You
the
can sell a property whatever on as is various basis पे property sale होता है.
So, but I have not paid the rent to the
May not have.
buyer.
You don't bother about it.
Therefore, that
You don't need to bother about it.
I will satisfy. I will satisfy on this point that I need not to require to challenge the sale deed because it was not within the domain, within the knowledge of the plaintiff.
प्रीत
At the
नहीं है
same-
क्या यहाँ पे?
जी एग्जिबिट सी बोला
प्रीत बुलाई. कल ही हम जजमेंट एक फॉरवर्ड किए. It has to be challenged. आपको बता देते हैं. देख लीजिए. Direct judgment on this.
But when that deed, sale deed is not came into force, because neither I have paid the rent,
आप मेरी बात सुनो.
nor here.
You satisfy that it was not required to be challenged. बात करता हूँ. You satisfy that it
Yes,
was not.
yes, I will satisfy. I will satisfy.
कब? कल?
कल एक अगला अगली
देखिए. Second appeal number 5 of 22. The learned counsel for the parties are present. This appeal has been admitted on two substantial questions of law framed by the order dated 2/8/2023. by giving the foundational background, the learned counsel for the appellant has submitted that on 6/5/2005, there was an agreement of sale between defendant number 1 and defendant number 3. And with respect to the same property, there was another agreement of sale dated 6/9/2005 between plaintiff and defendant number 1. इनको जरा दिखाइए, कल परसों दो जजमेंट्स आपको भेजे हैं. He submits that suit for specific performance of contract on 29/5/2006, the defendant number 1 executed the sale deed in favor of defendant number 3, and thereafter the suit for specific performance of contract was filed on 7/6/2006. But no prayer was made to set aside the sale deed. He has also submitted that the sale deed was exhibited as Exhibit C before the court, but the plaintiff did not take any step to challenge the sale deed. The learned counsel submits that once the sale deed was already executed with respect to the property by defendant number 1 in favor of defendant number 3, there was no question of grant of specific performance of contract and to direct for execution of sale deed by the defendant number 1 in favor of the plaintiff. The learned counsel has further submitted that the learned trial court was of the opinion and has given a finding that there was no partition but the appellate court has reversed the finding by holding that there was partition.
In the suit of specific performance.
He submits that in the suit of specific performance there was no occasion to enter into such a dispute as to whether there was any partition or not. यही आपका केस टोटल?
जी, the onus is upon the plaintiff claimant that there is a partition.
He has also submitted that the onus was upon the plaintiff to prove that there was a partition and the suit property fell in exclusive possession of the defendant number 1 by virtue of such a partition,
for getting a specific,
which could be subject matter of agreement dated 6/9/2005
yes,
and to get the same
for a specific performance of it.
same implemented through specific performance of contract. हो गया आपका पूरा कहानी?
जी, एक सब्सटेंशियल क्वेश्चन अगर आप बोलिएगा तो हम फ्रेम कर
नहीं फर्दर आप कुछ नहीं.
नहीं, पावर है हजूर को,
नहीं,
सेक्शन
ऐसा-
105 में आपको पावर है. एट द टाइम ऑफ हियरिंग आल्सो इफ सैटिस्फाइड तो लॉजिक फॉर
The learned counsel appearing on behalf of the respondent has opposed the prayer and has submitted that there was no need to challenge the sale deed dated 29/5/2006 as the plaintiff was seeking to enforce the agreement dated 6/9/2005 by filing suit on 7/6/2006. He has also submitted that the plaintiff had no knowledge about the sale deed executed on 29/5/2006. And therefore there was no occasion to challenge the same in the suit. The learned counsel has also submitted that he shall satisfy this court that there was no need to challenge the sale deed dated 29/5/2006. Still, the specific performance of contract would be granted.
20
इतना दिन बाद सर ऐसा नहीं होता है. हम इतना आपको क्या लग रहा है? इतना मेमोरी नहीं है हमको. इतना लिखा दिए हमको.
Otherwise, I am busy on 23rd.
आप बिजी से नहीं.
No,
आप
no,
पार्टनर
it-
मैटर
it-
सबको
it-
बिजी में बोल. बिजी में मत डालिए. आप समय निकालिए.
24.
24?
My colleague is not available on 20.
भाई ऐसा आप लोग का ये सब इक्वेशन नहीं चलेगा, आप ब्रीफिंग पहले से लेके रखिए,
नहीं, इनका शेड्यूल पहले से था, ये सिर्फ केस अभी
नहीं
आया।
करना चाहिए था,
तो आप समझिए, हमको नहीं बोलना।
वो हम नहीं जानते।
29 को बोली मैं सीनियर 29 को रख
आपके अनुसार हम तो कल सुनने को तैयार हैं, क्या ही हम आपको टाइम देंगे इसके लिए, बताइए।
तो कल सेकंड हाफ में केस कोर्ट में रहेंगे, आप चाहिए
मंडे को सुन लीजिए, मंडे को नहीं, मंडे को चलिए सेकेंड हाफ, मंडे सेकेंड हाफ करिए, तो सिंपल सा मैटर है, ठीक है। At the request of the learned counsel for the respondent, post this case for further hearing on Monday to be taken up at 2:15 as the first case. Done?
My lord, if possible, I will get the order of the court today.
आपके सामने लिखा है,
Yes,
अगर
yes, yes.
कोई
That is in my
कंफ्यूजन हो
mind.
तो
That is in
यूट्यूब
my
खोलिए
mind.
और देख लीजिए, ठीक है,
Yeah.
इतना प्रेशर मत डालिए, यूट्यूब रिकॉर्डेड है, आप खोलिए, ऑर्डर यही निकलेगा, ठीक है। प्लीज कहाँ है, दिखाइए तो कौन कौन सा जजमेंट आपको भेजे हैं। आप मेरे जजमेंट को ठीक से रखा करिए सारे। देखना पड़ेगा, कुछ और भी जजमेंट भेजे हैं। अच्छा, हमको जजमेंट मिलेगा तो आपको भेज दें, कभी कभी हम दूसरे साइड में भी भेज देते हैं, किसी और को भी कुछ याद आता है तो ऐसा ना भूल जाते हैं बाद में, किसी या तो हम कहीं देखे हैं या याद नहीं। एनीवेज यू डू इट
Yes.
ऑन मंडे।
Yes, problem.
This case item 22, second appeal 254 of 2018.
Yes. Plaintiff did not appear.
That much
No,
we can answer.
yes, answer that.
Number one, this is not your lordship will see that there are the law I think is very well settled on this point. Whether to what extent can a power of attorney holder depose in absence of the plaintiff from stepping into the witness box? If anything which requires the personal knowledge of the plaintiff, to that extent the power of attorney holder cannot. Now, most of the judgments in such cases is this case of the specific performance merits. But you will find a series of judgments of the Supreme Court. Mostly those are suits, appeals arising out of suits for specific performance. Where the Supreme Court says that a power of attorney holder cannot prove the willingness and readiness of the plaintiff, because that it is in that background, that context, not that all these. But the law which says that if the plaintiff, if something is to be deposed for the personal knowledge, that the power of attorney holder can't do it. More so in a case where the power of attorney is granted subsequent to the suit. Is granted. But which is not something which is not required, born from the knowledge, personal knowledge of the plaintiff. To that extent, the power of attorney holder can be imposed. So that is not fatal. Where other witnesses minutes are also supporting the case. There are judgments to that. That is one. Number two minutes here, suit was instituted for eviction on two grounds. One is personal necessity, and other is default. Personal necessity with the sale of the property automatically goes. The personal necessity of the original plaintiff.
Is it the suit was for specific performance?
No, this is eviction suit.
Eviction suit.
This is, I am giving a background where the judgments I have found or not are mostly in the context of specific relief. Here is a case of eviction suit instituted on the ground of personal necessity and
You are the
default.
tenant.
I am the landlord.
Landlord.
I have succeeded in two courts. I am the
Yes.
respondent.
Yes.
So to the extent of personal necessity, obviously with the sale of the property, that cause of action disappears because the original landlord's personal necessity cannot be my personal necessity. Number two is default. Default power of attorney, we have proved, we have said that after the property was purchased, sold, he has not paid us the rent. His defense which he has set up is, he does not say I paid rent. He says, no, I had entered into an agreement to sell, to purchase the property, and I have given a lump sum. So that was to be adjusted towards it. So there is no defense.
You see, when it says about default, so it was certainly the personal knowledge of the landlord. It was certainly the personal knowledge of the landlord, whether there was any default or not, whether any amount was to be adjusted or not, isn't it?
Yes.
And whether the earlier landlord has informed the subsequent landlord. In order to constitute a case of default, you are the subsequent landlord?
And the suit was issued after my purchase.
Yes.
So
You are the subsequent
I
landlord?
am the subsequent landlord and I am seeking default from after my purchase.
That's right. Did you inform them?
Not required. In law,
Not
it is
required means who will, how will they dream of it that who is the landlord?
Atonement is not required in law. Number one.
No, let us assume Mr. A sells the property to Mr. B, while Mr. C is in possession of the property as a tenant. How will Mr. C come to know that he has to pay the rent to Mr. B?
So in law matters there is the position is that atonement is not necessary. Let me for a moment keep that in the back burner. The point factual is that as I informed, the tenant had instituted, purportedly entered into an agreement for sale with the original landlord, my vendor. There was a suit for specific performance pending.
We are not bothered about
No, kindly hear me. I am coming from the facts. In that suit for specific performance,
Tell us from the
I am telling
judgment.
from the record minutes.
From the
If-
judgment.
If your lordship will hear me, then only I'll tell.
I am hearing
The
you.
point is that he himself implemented me as a party after 2 months. So where is the question of lack of knowledge?
Show me from the
Yes.
judgment. The trial court judgment and the appellate court judgment. You show me the knowledge of the appellant that he had to pay rent to you.
Kindly come to page 10 of this is trial court's judgment. It is when it starts at para 6.8 is DW1 and para 6.9 is also DW1. So
And
different.
we also have to see the point of law framed.
I will
It is
confine myself
second
to, yes, I will confine myself to the point of law. Your lordships are probably additionally framed. So this question is
There is no additional framing of
last lordships had framed another question on 9th of January.
For this another substantial question. Yes. 9th of January. What was the original?
1st of February. Whether
First
the
of-
impugned order,
Yes, can you read it?
whether the impugned judgment and decree passed by the learned court below stands vitiated for not taking into account the pleadings of the parties which clearly establish that during the subsistence of the tenancy, plaintiff landlord had executed an agreement to sale dated so and so in favor of tenant defendant, and as such, since the relationship of landlord and tenant ceased, so and so. So now kindly come to your lordship's question, and the answer is at page 10. of the trial court judgment.
Yes. Before that, we will see the relief prayed for in the trial, before the trial
Sorry,
court.
ma'am?
What was the relief prayed for?
Eviction was on the ground of default and person.
The trial court judgment,
Trial court judgment is dated on 10th of April 2014.
the issues framed,
Issues
para 4,
10 issues.
limitation, specific.
No, can I just straight away answer that question so that that issue is not closed?
Yes.
Page 10, kindly take page 10. Paragraph 6.9. However, at para 25 of his cross-examination, that is DW1, that is
Para 6.9.
9. However, at para 25 of his cross-examination, he has admitted that his father was the tenant in the suit premises, and after his death, they became tenant here. At para 26, he has deposed that they have been paying rent to the vendor of the plaintiff at the rate of 150 per month. At para 29, he has deposed that after getting information the sale of the suit premises, he has made the purchases, namely the plaintiff and Abhilasha Jain party in the said title suit of so and so on 26/3/2008. Our deed is of February 2008. At para 30 of his cross-examination, he has admitted the dispute presentation. So what more? It is completely within their knowledge.
And what is the period of default as per your claim?
Yes, as per my claim, the period of default starts from 9th of after my taking over.
No, let us see.
9th of that is not the page 3 of the judgment, para 2.7. I have said 8th of February, but from the date where I purchased the property.
Just a minute.
After 2 months, 9th of May. I said,
Page 3 of the
Page 3,
judgment. Yes.
the cause of action for the suit arose on and from 8 to 2008 when the plaintiff purchased the suit building for a use and occupation, and also from 9/5/2008 against the defendant at judicial response. That is after 2 months when they did not pay for 2 months. Which minute this statement which I read out was at paragraph. This statement which I read out was a paragraph 13 of the plain, and their reply to paragraph 13, it's very interesting. Paragraph 13 they say, my lords, they have not. 13 they say is false and denied. Just at paragraph 16 they say false and denied. So my answer to that is order 8 rule 4, my lords, says there cannot be an evasive. 5 also, there cannot be evasive denial. Because it's already 4:30.
So you want to say that the power of attorney could have deposed, and there was the decision was not based on any personal knowledge or anything. The suit was filed by the subsequent landlord,
Purchaser.
and the power of attorney was that of the subsequent purchaser.
The findings are otherwise not perverse or anything of that sort. So there are few judgments on these points which I can place notes either.
Your sale deed is
8 to 2008. Exhibit.
agreement of sale is 22 to 2006.
That is there. The defendant's
There.
agreement to say.
They did not take any steps to execute.
No, they have instituted a suit for specific performance.
That is pending.
That was pending. Now what has happened is so it's still pending. So, but that would not make a difference. That is what I am saying. Because what will happen is, even if they are evicted and the suit is decreed, their suit is decreed, natural courts will follow. I have been implemented as a party, I'll go and explain. Otherwise, it's an unregistered document which there are defense which I can use.
Since the title has not yet vested
Correct.
in favor of the landlord,
Yes.
therefore under such circumstances he cannot be said to be the owner of the property.
Absolutely. An agreement to sell, what I have been taught by Mr. Manju Prasad is, will only give a right to sue, no interest in the property.
Certainly, agreement to sale,
53A has also been
Yeah.
taken care of
No, it's an unregistered document.
but
post 2001.
there is one judgment of Honorable Supreme Court reported in 2010 AIR-CW 1411.
What does it say?
Para 9 is relevant. Here the question is, it is not only the agreement. The agreement is under process para 9. There can be no dispute about the general proposition laid down by the High Court in such and such, but the High Court ignored the fact that though the first appellant had admitted that he was earlier the tenant under the previous owner, he had also specifically pleaded that the previous owner had executed an agreement of sale and permitted him to continue with possession in part performance of the said agreement of sale, and that therefore ceased to be a tenant from the date of agreement dated 11/6/1997. That the relationship of landlord and tenant between him and the previous owner had come to an end, and that as on the date of sale by Sir Anthony Swamy in favor of the respondent, he was in possession in part performance of the agreement of the sale and not as a tenant. In fact, the first appellant also filed a suit for a specific performance. Here also ignorant suit for a specific performance is pending prior to filing of this eviction suit. Agreement of sale dated January 67 and delivery of possession in part performance as alleged by the first appellant, then it did not become a tenant under the respondent, and the decision of Haji Iqbal Sharif relied on by the High Court. It is with respect to substantial question number 1, formulated on 1st of February 2019.
पावर ऑफ अटॉर्नी के बारे में आपको क्या
Pardon?
पावर ऑफ अटॉर्नी के बारे में आपको
पावर ऑफ अटॉर्नी के बारे में मेरा कहना है,
कौन सा
Power-
ऐसा पर्सनल नॉलेज था जो आप एक्सट्रैक्ट करना
Yes.
चाहते थे?
The suit was filed on 2/10/2010. Suit for eviction. Power of attorney was given on
हाँ ठीक है बाद में दिया
2013
पेंडेंसी ऑफ द सूट
में 2013 में आया. Just I'm giving the exhibit number. Yes, it is dated 20. Exhibit 2 है power of attorney. कब कर रहे थे? 13
ठीक है बात कहे तो
13 का.
हाँ तो
Therefore, default right from 2008 after purchase till 2013, Abhilasha Jain has got no knowledge.
नो नो द
She had
पॉइंट
only the person default on behalf of plaintiff.
आपका तो केस ही नहीं है कि उनको रेंट दिए दैट इज नॉट योर
हमारा नहीं
केस
है. But how the plaintiff will prove that I am defaulter if he has not been examined?
it is your case that you did not pay the rent because
Yes.
there is a specific
Suit was
performance.
paid.
suit is pending, there is an agreement, and and
Yes, sir.
thereafter, after
Certainly.
the agreement, so
But
therefore
who-
there is no
but who
no
will prove?
requirement of any knowledge.
But who will prove it?
Who
It
will
is the
prove it?
plaintiff
Means,
to
no,
prove.
no. If it is an admitted fact, who will prove it? It is an admitted fact that you did not pay any rent. It was your
Yes.
specific case that you did not remit any rent
Then the-
after you entered into an agreement.
Then the illegality committed of both the courts below, that they should have take the eviction suit during pendency of the specific performance of contract suit.
That we will see. But power
Next.
of attorney वाला issue जो है आपका,
पावर ऑफ अटर्नी वाला
personal knowledge तो
Personal
कौन
knowledge.
सा ऐसा personal knowledge
Kindly
पे
have a look
उसको
to
उनको
the-
cross examine करना
Kindly
चाहिए.
have a look to the provision of law, PBC Act देखा जाएगा, section 11(1)(c).
क्या है 11? अब 11(1)(c) में क्यों पहुंच गया?
नहीं बस क्यों point wise, not detail. Law बोलता है specific. Section eviction of tenant, 11(1)(c), where the building is reasonably and good better required by the landlord for his own occupation or for occupation of any person for whose benefit the building is held by the landlord. Proviso है partial eviction का explanation 1 देखा है. In this clause, the word landlord shall not include an agent referred to in clause F of section 2. Meaning thereby it is the only landlord has to depose that she personally requires the premises for
नहीं
his
नहीं, पर्सनल नेसेसिटी का तो ग्राउंड ही नहीं है. बोलते भूल जाइए पर्सनल नेसेसिटी. Once the suit property is sold, the personal necessity of the original landlord does not exist, and they say forget about personal necessity. He gives up personal necessity. खाली default.
डिफॉल्ट का तो 2008 से लेके कहीं इनका प्लीडिंग नहीं है.
अरे भाई आप ही का केस है कि हम रेंट नहीं दिया.
2008 से हम पेमेंट नहीं किए.
तो फिर इनका प्लीडिंग का क्या जरूरत है इसकी? It is your case that you have not paid rent thereafter.
Yes, sir.
What
That
will
is-
be your status? Whether there will be a relationship of landlord and tenant, these are the things which will be considered.
I'm not accepting relationship of landlord.
Yes, that
This is
aspect we will
plaintiff. This is
consider
plaintiff.
in the
Yes.
light of this judgment. But so far as power of attorney is concerned, उसमें तो अब कुछ नहीं. Admitted fact है that you have not paid rent. The reason may be n number of reasons.
Yes.
Right?
That is
It
right.
could be a genuine reason. But it is a fact that you did not pay rent.
Yes,
And it is also a
and
fact
it
that
has
you came to know about it soon thereafter, as per your own evidence.
After filing of the suit itself, we are not paying rent since 2008.
That's right. That's right. You are not paying rent since
जब से वो
2008.
खरीदी है तब से हम उनको पेमेंट नहीं कभी की.
हाँ, ठीक है.
और न कोई डॉक्यूमेंट आया that there exists a relationship of landlord and tenant
तो वो
with
तो कोई
his
है ही
vendor.
नहीं. They are simply claiming that they are successor in interest.
Yes, but
Of the
no
landlord.
knowledge, not to my knowledge.
No, ऐसा नहीं ना आ रहा है. That it is not to your knowledge. आप ही के क्रॉस एग्जामिनेशन में आ रहा है. That you filed your specific performance, making them as
तो
party.
2006 से पेंडिंग था वो तो.
नहीं, उसके बाद उनको भी
बिक्री
तो
हुआ है
पार्टी.
2008 में.
उसके बाद उनको भी तो पार्टी बनाएंगे. अभी जो ये स्टेटमेंट पढ़े.
हाँ तो सेल का जब पता चलेगा तो उनको पार्टी बनाएंगे.
हाँ तो ठीक है, उसी समय तो बनाए हैं. तो सेल का तो आपको पता है ना.
2008 के बाद तो पता चला, 2010 में पता चला तो बनाए.
2010 में पता, 2008 का पता.
But Abhilasha Jain has not come in picture of eviction suit. Only the Kanta Jain. क्या नाम है? हाँ, Kanta Jain. Plaintiff is only Kanta Jain.
आपने 26/3/2008 को उनको पार्टी बना दिया.
हाँ ठीक.
तो आपको 26/3/2008 के तो पहले ही नॉलेज हो गया ना.
और वो ऑर्डर भाई ऑर्डर रिपोर्ट करना है तो
पिटीशन फाइल करने से ही हुआ होगा, चाहे कोई भी फाइल किया होगा.
ये बनाए तो भी नॉलेज तो हमको हो गया.
थोड़ा देर और लगेगा. कल हम डिक्टेशन भी देंगे और इसको कंटिन्यू.
Can I just, this is your lordship will dictate. I am very, I could not search, that is my mistake. This judgment is actually a report, the judgment cited by them.
It's a
the judgment cited by them,
Yes.
it actually clears the entire thing. It says that if a suit for, kindly read para 10, if your lordship gives me 5 years to wind up, so there will be clarity. This is the law. We may, however, clarify that a mere assertion by the tenant that he is in possession in part performance of an agreement of sale, or mere filing of a suit for specific performance by itself will not lead to the deferment of the eviction proceedings under section 43 of the new act. But now, kindly see in their favor. But where the respondent in an eviction proceeding under the Rent Act denies the relationship of landlord and tenant, contending that he is not in possession as a tenant and produces and relies upon an agreement to sell in his favor which confirms the legal possession in past term, and a specific performance suit is pending, and there is no lease deed or payment of rent from the date of such agreement to sell, kindly note, from the date of such agreement to sell, or no acknowledgement of atonement of tenancy and section 43 of the new act may apply. But a word of caution, courts dealing with summary proceedings against tenants under rent acts for eviction should be wary of defendants coming forward with defenses of agreement of sale, lest that will become a stock defense in such petitions, unless the court is satisfied prima facie that the agreement is genuine and defense is bona fide. It should not defer the proceedings for eviction under the Rent Act. So there is a section 43 in the Karnataka Act, but I am, for a moment, Supreme Court says that if after the agreement is for sale is executed and my possession thereof is in part performance, that means I have stopped paying rent after that, and then a subsequent purchaser coming, the eviction suits will not go. Now kindly come to paragraph 12 of their written statement.
Where do I find that?
A written statement is not in the records. Or the reference judgment.
Last time your junior was pointing out that. But I can lay my
What
hand
they
on
have
it.
said is, I just wanted, because this is very relevant.
Para number?
Para number 12 of the WS.
Para 12.
हाँ एक बार judgment है क्या lords? Judgment is the lordship comes to para 3.3 of the trial court judgment. Actually यहाँ पे para 3.2 if your lordship can come, I think that will suffice.
3.2.
Yes, it has been admitted that the suit premises is situated within the jurisdiction of this court in Moza so and so, plot number so and so, but it is false and bogus as claimed by the plaintiff, or has any right as a landlady in the suit premises described in the schedule having the set boundary and area described in schedule A of the plaintiff. Now, according to her, illegally makes sale deed in her name bearing number so and so dated 8/2008. The defendant is not the tenant under the plaintiff, or has ever paid any rent, nor have paid a monthly rent of rupees 150 per month to Govind Kumar or Sandhya Badani, and there is no relationship of landlord and tenant, whereas defendant's father Vijay Kumar Jain was the lawful tenant of the suit premises under the previous landlord Govind Kumar and Sandhya, were regularly paying remitting rents to the tenanted premises to the previous landlord without any default or arrears of rent. The rent is not paid as eligible. So they are admitting that under the previous landlord they continue to pay rent. So they were not in possession of the property by virtue of part performance of an agreement to sell. They themselves say under the previous landlord I was a tenant. Now comes atonement, which the Supreme Court says is not necessary. Atonement means that you don't have to recognize me. So para 12 I think is very clearly worded, that they were regularly paying rent to the previous landlord. So after, as the learned senior counsel also says, after I purchase the property, they stop paying rent. So that is not a valid defense. Even the Supreme Court judgment cited by them say that is not a valid defense.
Only one judgment I would like to refer to that. Then on point power of attorney और कुछ
लैंडलॉर्ड टेनेंट का लड़ाई हुई।
पावर ऑफ अटॉर्नी में एक जजमेंट और केवल देना चाहेंगे 2005 सुप्रीम कोर्ट 439
Should we
para
also
2021 वो बहुत कॉमन जजमेंट है जान की बात
कल
है
ले आइए, कल सुन के ही ऑर्डर करेंगे, ऐसे नहीं करेंगे। पावर ऑफ अटॉर्नी।
पावर ऑफ अटॉर्नी पे 2024 में 2 जजमेंट आया है, वो पूरा एकदम लॉ को क्लियर। दे आर बोथ द जजमेंट।
आया है कुछ जजमेंट।
हां, 2 जजमेंट, एक एससीसी में रिपोर्टेड है।
कहाँ है वो?
हां है ऑनलाइन। इसी तो कह रहे हैं, शुड बी बर्डन टुडे और
अगर है तो दे दीजिए।
हां है, मेरे पास पूरा कंफर्मेशन है। 124 से But these are all suit for specific performance. Therefore, I was not trying to draw distinction, but the law will not change.
Essay number 254 of 2018. The hearing has to be inconclusive as the court time is over. Post for further hearing tomorrow. 12 बजे.
My job is done.
I don't know. अब क्या होगा अभी पढ़ेंगे तब सोचेंगे.
हाँ,
12 बजे फर्स्ट 10:30 बजे से शायद कंटेम्प्ट मैटर्स.